Thank you, Madam Chair, Mr. Chair. This is probably one of the more serious issues in the years that I've been a legislature that I've been asked to review, participate in, and prepare comments for. So although I don't normally refer to writing, I do have notes that I'd like to stick to. And I appreciate very much that and take very seriously that we were appointed not to take a position. And so in the course of my discussion, it is not to take a position, but to raise very seriously what leadership asked us to do, which are more clearly define the issues that need more review and focused deliberation. And I trust that these issues will be raised and not dismissed as efforts to kill the bill, but as they generally are being raised as what we heard from the deliberations and believe the General Assembly should continue to focus on. And after the hearings last year and the presentation this fall, it was clear to me that this bill is an important issue for our society. And I commend Delegate Pendergrass on being a pioneer and a leader and bringing Maryland to this state, because society has been clear with us that end-of-life issues are very important. And how Maryland will lead the way is our way and our pioneer way, not to rubber stamp Oregon. I believe that before we proceed, and the issue for deliberation was, why are we proceeding? Because we must understand or define for the rest of the legislature and going forward what the state interest is. And I think that question broke out in two different ways. Is the state trying to declare a right to self-determination, autonomy, a libertarian authority to end life when there are prescribed circumstances? And Ms. Maynard, the young advocate, and Compassion and Choices asked us to support this act because they have a desire for those in our society to be able to make decisions on how they want to die on their own terms. A significant part of the testimony was the state should develop the right for people wanting control. Compassionate Choices, the Unitarian Congregation, the Executive Director for Seniors, and Elizabeth Cooney all supported that they wanted this bill to be amended to be more expansive. They wanted it to allow dementia, spinal cord injuries, severe mental illness. They asked us in their testimony to accept this and develop this policy as a state-developed right to make an autonomous and individual private decision. And so I think that's the issue for deliberation. What is our policy and what is our philosophy? Is this legislation designed to support people who want to reject palliative care options? The Oregon testimony and report has stated for us that the number one reason is autonomy, the failure to be able to continue to enjoy life, and loss of dignity. And so if that is our state purpose and our state policy, then we need to not hide behind anything else and state that or deliberate that more further. If the policy is the state undertaking the development of this serious issue to address pain and suffering concerns for those with a particular diagnosis, if shortening or addressing pain and suffering is the goal, then the state policy and the deliberation should be what we are doing to make sure that palliative care, comfort care, hospice care, and end-of-life decisions like the CMS regulation are incorporated into our state requirements and offered to our citizens equally and fairly, notwithstanding private insurance or not. But if our state interest in our policy is about pain and suffering, then we as Maryland should make sure also that the bill is amended to require that physicians are making an affirmative finding that there is no reasonable medical palliative treatment available and pain management will not be effective. If we are talking about, as a state, creating this humane option, allowing this humane option to be available, I think we have a responsibility to make sure that there are intervening options available along the way. We have to ensure that access to pain and suffering and palliative care are a priority for our state. And we have to lead the way. We led the way in small group market reform. We led the way in high-risk pools. And we have been a leader in health care and affordable health care. And so in end of life now, not picking just one option or not focusing on an end step, but really continuing to be a leader in the intervening avenues that are available, I think is important and subject to further deliberation. So I think it's imperative that we make a decision on what policy is driving us, because the state interest will be very important to anyone on review, including the court. The legal issues that my colleague raised, I think, from the Judiciary Committee, that we are always likely to want to continue to look at the wording and work with staff, is in the area of immunity. There is immunity if you proceed through this bill and you make the correct determinations. But really, what immunity is available if you made the wrong determination that a person was competent, or wrong determination on their diagnosis? Because you don't want to incentivize or unintentionally create the opportunity for there to be no avenue to pursue a healthcare provider that's not operating in the appropriate standards of care. So is there immunity or is there liability if you're not operating under the appropriate standards of care? And the bill needs to be cleared up. As my colleague Delegate Smith said, as the Judiciary Committee, we will continue to probably advise or look at the penalties. And if a violation of this very serious statute is first-degree murder, then we're going to have to talk about whether the penalties are correlative or not. We're going to have to make the hard decisions of, if you violate this bill as an individual and or as a physician, what and how correlative should the penalties be to our current criminal statute? Because it will be the taking of a life. With the scope of practice issues, it's unclear whether, if we've allowed other practitioners to prescribe, that we can limit their ability to prescribe. I guess we can create a state interest, but we do often allow correlative scopes of practice to do and engage in the same things, and we're just limiting this to physicians. I'm not taking a position one way or another, just raising what I think the testimony. I think one of the most important things that I've learned and read is that we need a better definition of what self-administer means in our bill. That's the crux. Depending on the intended limitations, and what and expressly do we intend as a state when we say self-administer. A lot of the law review articles have suggested that self-administration can be interpreted as merely ingesting the medicine, and that without more precise wording, it can be intended as allowing other individuals to assist people with the ingestion of the medicine. The Oregon Death with Dignity Guidebook is significant, and I agree with Delegate Hill's proposition and even go further that their guidebook is very detailed, and we in Maryland should have as detailed of a guidebook. But Oregon intentionally says in their guidebook that they leave what self-administration is intentionally unclear, intentionally, so that it leaves open to healthcare agencies and professionals the opportunity to establish their own standards regarding what assistance with administration and medication will mean. It admits that it does not rule out the opportunity that the medicine could be administered through a G-tube or an NG tube. And the Oregon Guidebook specifically states, without clarification, even the Oregon Guidebook admits that interpretation about the NG or G-tube administration makes it easier to administer to an unwilling person. If our state is intending to mean that a person pick up the medicine and take it themselves, then we need to be a little bit more express. And if that's not what we mean, that we want other people, notwithstanding their disability or inability to use their hands and swallow, to avail themselves, then we need to be express with that. And the reason we do is this controversial issue will then be interpreted by a court if it's challenged on an equal protection measure. And the state at that point is responsible for setting forth its express policy, because the court will look at what is the public interest. What was the legislature doing? What does the file say? What does the testimony say? More importantly, what does the statute say is the state public interest that we are trying to protect? Do we have a right to take action to protect against suicide, supported by the interest in prohibiting intentional killing, preserving life, preventing suicide, maintaining physicians' roles as their patient's healer, protecting the vulnerable from indifference, prejudice, and psychological and financial pressure to end their lives, and avoiding a possible slide toward euthanasia? If that's our state interest, we have to define what we mean in self-administration or not, because that will be what the court looks at. The Supreme Court's determined that there's not a fundamental right to aid in dying, and heightened scrutiny is not going to be applied in this case. So we are going to have to be express if we intend to allow people to do this, and the disabled cannot avail themselves of it, what we're doing by not allowing the disabled to take advantage of this.
We've had 10 minutes now. I
All
hope
right,
you're
let me
coming
wrap it
to a
up.
close. That'd be
I
great.
will. I
Thank
had my timer on. I didn't realize it was 10 minutes. The physicians have clearly said to us that they have concerns, and I appreciate that they've been addressed. But I think that all of us, in the absence of time, need to take seriously the AMA's stated position. E2.2111 speaks very seriously that our nation's state medical society and our state medical society have clearly said that although that this is tragic and some patients do need it, allowing physicians to participate in assisted suicide would cause more harm than good. I think that there are broader issues. It's not unrealistic for us to believe or characterize this as a slippery slope. It is, and I think that in going forward, our obligation was to raise some of those serious issues, which are the pressure on the disabled, the change in family dynamics, that we will be creating an option that people feel they must avail themselves of, the vulnerable, the sick, those that don't want to spend their financial resources, and how do we protect that, the change in the insurance industry dynamics. So I appreciate the amendments. I'm excited that we will deliberate on some very serious issues and be a leader in end of life and not a rubber stamper for Oregon and California. I appreciate the opportunity to be part of this important discussion, and none of it was intended to take a position, but rather raise what we should continue to deliberate on in the coming session.
Thank you, Madam Chair and Mr. Chairman. We have been working on this bill all summer and fall. It's critical to note that our